Hey, I'm Marc Stevens. Welcome to the No State Project, the Wednesday edition of the No State Project. Of course, we're commercial free because we are streaming. We're doing a video stream. It is May 10th, 2017, episode 20, the big 2-0 of these Wednesday broadcasts, which I love to do because, hey, there's no commercials. There's no flow. You know, we don't have to. A lot of times on the No State Project, the regular broadcast, we do go through the break, so we get a lot of off-air commentary and statements that are made that are available on the podcast. Thanks to Calvin, appreciate that. But it's still, you know, with the interruptions, and I got to kill the feed and whatnot. Blah, you know, here the commercials. Here, no, we don't have that. And same calling number here on the big show. It's 218-632-9399. That's 218-632-9399. You can also Skype me, but instant message me first at Frank Rizzo 3, and then I'll bring you up onto the big show. And yes, you probably noticed I'm doing things a little different today. Still in the fortified compound, but trying to make things better in the studio. So I got rid of the banner, so I got an old one behind me. So that's the old government indicted one that we did at what do you in Libertopia when we were still doing that, which is unfortunate we're not doing that. But hey, got to get something going here in Phoenix with a big focus on music. So hopefully we can get that together. Maybe Calvin is going to be able to help work with that. But we still want to be able to do the No State Project live, the Saturday broadcast. Maybe even a Wednesday broadcast. We just change the time where we do the Wednesday broadcast at a place with an open mic night where we can do the show for a few hours and then just go and do what's really important, and that is play some blues. Would love to do that. I want to just get out of the way here. Jackalope Freedom Fest, still going on. It's not defunct like unfortunately what happened with our San Diego Libertopia. But Jackalope Freedom Fest right here in Arizona. It's about an hour and a half or so northeast of Phoenix. And I've only missed one, and I'm definitely planning on going. It's July 31st through August 6th. So I usually only do a Saturday, but I'll definitely be there all day and do a broadcast from there. Last time, Calvin was there, which was great. And we were able to talk about Joe in Hawaii's getting marijuana charges thrown out. All of them tossed out. Not a single shred of evidence to support their claims. And if you're the type of person who thinks, hey, certain people are privileged and they don't have to have evidence, fungal. That's my response to that. I'm not even going to entertain this crap anymore that somebody doesn't need evidence, because you know you're dealing with someone who's dishonest. Stay away from these people. So anyway, remember, Jackalope Freedom Fest, July 31st. You can get your information at, well, you can just look up Jackfest Freedom Festival, Arizona, but it's actually at jackfest.rainberry. That's RAYNE, Berry, BERRY.com. And you can get the information on where to go. It's in Bacchus Meadow, which is pretty damn nice. So if you want to get an idea of what it looks like, just check out some of my the Jackalope Freedom Fest videos, so you can get some kind of an idea. It's beautiful up. It's not desert. This is high. This is a few thousand more feet higher, and it's beautiful. I wish I could go there for the whole weekend. I can't. But we'll definitely be there for the Saturday. We'll see what happens. Maybe things will allow for me to be there for more than one day. But getting things ready here and moving things around here in the fortified compound in the home studio here, I found, not that it was lost, but we can get. I think we got that in focus here, maybe on the live broadcast. But this is the very first printed edition of Adventures in Legal Land. And so, yeah, we're going back quite a few years here. This is 2000. Actually, going through the proof process was late 2002. Yeah, wow. I actually thought after 9/11, I'm going to have to get a job. There's no way I'm going to be permitted to work and do what I'm doing. But I was working on this, and I still released it. And so the original, something happened. There was so many problems with the printing of this damn thing that when it came out that the judge's robe was blue, I just let it go. And you notice this is 6x9, which is one size in printing size larger than what it has been, and that the judges, hey, look, I can barely do Photoshop now. So when they screwed this up and made it blue, it's such a horrible process. I just said, screw this. We'll fix it later. Get the damn thing. I got to tell you, I don't have the second one. The second one they won't give me. They won't even let me buy it. But it was before. It was late 2002. I didn't know about on-demand printing. I'm almost embarrassed to say what this cost. So if anyone thought, hey, Marc Stevens just some scumbag in it for the money, this cost me the same as the first run cost me. Yes, I had to borrow some money for that. These were $30 a piece. $30. I didn't make a cent on the first run. Nothing. But yes, I did. Thankfully, I found a print on demand that brought the cost down considerably. $30 for a 200-page 6x9. And yes, the reason why I picked 6x9 because one of my favorite books from Banle and Grinder, their books are about the same. So they were 6x9. So I just used that as a model. Figured I would do that. But where black is white and where black is white and white is black, and other shocking discoveries from America's courtrooms. There's so many more shocking discoveries. So if you see behind me, I've got the government indicted thing there. A lot more in there because after Adventures of Legal Land, I started working with people, and I actually started doing radio shows, a lot of radio shows to promote the book. And so I got in contact with a whole lot more people in a lot more different areas. I wasn't working with people just in some parts of the United States. It was all over the United States. I started working with more people in Canada. And so by the time Government Indicted had come out, I had a lot of experience. So then working with people in Europe and also in Australia and New Zealand, which is always cool. So I wanted to bring that out. Good news and bad news. You know, when anytime you're dealing with these crooks, and I want to make it clear every show if I have to. We get a lot of tickets thrown out. I thought today I had 2 success stories, and I went and I checked my email, and I thought what I had there was someone who sent me documents on Skype, which is Frank Rizzo 3, that had also sent me the documents on, on email. But I opened up the email, it actually wasn't the same guy. It was a third success story. So one of them not so recent, but 2 of them are, which is really cool. One's in Tennessee, and another one is in California, which is great because California, there wasn't even a trial, which was awesome. And another one is someone who's using the material, the Socratic Method, as some have dubbed it. But we just, it's the Socratic Method without sacred cows. We don't allow for any sacred cows. All claims are subject to challenge that are being made against us. So that's cool. But there was a particular one. I'll get into the success stories in a moment. I didn't even set this up for the show. He gave me the information on Skype, and it was just you don't want to see something like this. You definitely don't want to see something like this. So he was on the show before, and he had mentioned about a particular judge. And he's got an appropriate last name, Michael Cox. Michael Cox. He's an Adams County judge in the 17th Judicial District in Colorado. And he had already reported on the show that this guy is just... When you make it to that age, and he's got to be over 60, you make it to age 60 and you have a full head of hair like that, you have no reason to be a cranky scumbag old man. I mean, really. Go to it's linked. It's been linked before on the show, I guess what I can do is I can take the link over here and I can relink it for people listening to the show in the No Stay Project Skype chat. So I'll post this excrement there for you guys to check out, this SOB. And Michael Cox, there's actual audio of this. So I'm not going to play it right now. The audio, I don't remember the username, the Skype username, so I can't find the actual video right now. I'm going to do it, but I will have it linked below for the YouTube video that will do with this. The guy asked a question, and Michael Cox, psychopath, Adams County Judge, Colorado, gave him 90 days contempt. He didn't even get to ask the full question. 90 days for calmly asking. See, there's no room for anyone to say he was being disruptive. He wasn't. There was no grounds to say that the judge is not there to answer questions. That's ridiculous. Somebody's trying to plead guilty. The prosecution isn't there, and the prosecution usually doesn't say anything. If they're willing to plead guilty, they just want to know if the prosecution has met their prima facie burden, and for the judge to turn around and say, I don't have to answer your questions, that is a scumbag move. Michael Cox. Honorable Michael Cox. Yeah, honorable if you mean prick. If you mean a violent man with psychopathic tendencies who's willing to put a man in jail for 90 days for asking a question, and he's not being disruptive. He's just asking if the prosecution has met their prima facie burden to that point, which is a perfectly legitimate, relevant question to be asking. So I don't want to hear any of this. He has no business asking questions. Bull. How the hell do you defend yourself against the charges if no one is going to disclose what's going on to you? If you're going to plead guilty, you have every justification for asking if the prosecution has met their prima facie burden. The fact that they have forced you into the situation and forced you into that room on the threat of jail or death, to say that you're not going to answer questions, crook. So what happened was he got out the next day because they didn't just put him in jail. They put him into a psych ward. A psych ward. So let that sink in. I'll probably have him up over here. I don't even want to have the guy's face next to mine. It makes my skin crawl wearing that stupid robe. Asking a question, just saying you want to ask a question, is that grounds to put somebody in a psychological ward and have So yes, they pulled him out and gave him the opportunity to plead guilty again, and they asked him, knowing what this guy did, that he had just spent almost a day in jail in a psych ward, knowing what this guy was willing to do to him. Yeah, he said he lied. Said he wasn't being coerced, entered the plea, paid a very small fine, and got the hell out of there. Now it's time to fight back. But even if you were a critic, how could you possibly, in any shape or form, try to justify putting a man in a psychological ward for a psychological evaluation because he asked a question, even if you think that the question isn't relevant? Really? Asking a question is enough? You think that that's evidence? That data shows, oh my gosh, the guy's asking a question. He must be freaking lunatic. Must be out of his mind. Lock him up. I'm sorry about the buffering, guys, but we get all this in HD tomorrow. We got to get this off the Ustream channel. We got to be able to... I want to get set up here with some acoustic panels and get off of Ustream. Hopefully we can get a better... You guys can help me with a better computer. We can go straight to YouTube and not have to do this. We'll do it straight on YouTube. But for those critics, I want somebody to try to form some kind of rational argument, some rational justification for locking a man up and in a psych ward to question his sanity, his mental fitness for asking a question. And you guys, I'll have it linked. We have the audio of this. This is not just me taking somebody's word for it on Skype or on my email. I heard this. Well, I don't know who recorded it, but they got it. 90 days. Now, imagine for a second. Imagine a legislator. You know, one of the anointed, one of the priestly class, one of the rulers. Imagine they tried to pass a law that asking a question was a 90-day misdemeanor. 90-day misdemeanor. Does anyone think that would pass? Even the most die-hard statists, one of these religiously reverent statists who think that all the state is great. It's man's greatest invention. Can you possibly expect that even a legislature would be able to pass a law making it a misdemeanor to ask a question? Again, he was not being disruptive. And I think I already mentioned, defending yourself, yeah, you're going to ask some questions. And when you're forced into the situation, the prosecutor has a burden of proof. The judge is supposed to be a fair, impartial, independent decision maker. Is he a fair, impartial, independent decision maker if he's willing to put your butt in jail for 90 days for asking a question? Sounds like a psychopath to me. Sounds like a damn criminal. And that's what Michael Cox is. He's a criminal. He is a criminal in a black robe, but he's a criminal nonetheless. Hey, but the judge isn't there to answer your questions. Okay, let's give you that, jackass. All these idiots that want to say the judge isn't there to answer your questions. Let's just give you that. Okay, you're right. You're God on a 4-foot throne. He's too good to answer questions from the plebes. He's too good. Fine. Does that justify a 90-day jail sentence? Think about all the other things that 90 days can get you. Asking a question? 90 days. I could even see contempt, $25. If you do it again, every time you ask a question, it's another $25. I'll give you even that. 90 days? I think the Latin phrase that we're looking for here is bigus dicus for Michael Cox. Maybe that's his Latin name. Bigus dicus. Oy, what a scumbag. What a scumbag. Oh, you just want to insult him. Yeah, you're damn right. He put a man in a psych ward for asking a question. You're dealing with filth. You're dealing with a criminal in a black robe. What do you say they're all criminals? Hyperbole. They're crooks because they force strangers to give them money. Just as I'm a criminal, if I was to pull something like that, they're just as much of a criminal. Screw your double standards. So that's something hopefully we can get, and I'm going to work on this. I've already contacted the Adams County Risk Management. A claim such as this is not handled by risk management or human resources in Adams County, but it's initially handled by the county attorney. So be helping with a complaint against the psychopath Michael Cox regarding that. Imagine that. 90 days for asking a question. And I'm telling you, you'll hear it yourself. He did not raise his voice. He was not aggressive in any manner. He was standing there asking a damn question. Psychological evaluation. The one who should be getting a psychological evaluation is the narcissistic prick who's on Michael Scott. No, I don't mean Michael Scott, Michael Cox. Oh, man. But there are some videos that I will do where we have some of the success stories. But Elliot sent me from California that the prosecution, after he filed the Deburr, which the motion to dismiss is called the Deburr in California, he filed the Deburr with the discovery request. The prosecution withdrew their complaint, and it was accepted. Filed a motion to withdraw. And what I've got here is a document that confirms that, yes, the ticket was dropped. So the balance due is 0. The judicial officer is Carlton Biggs, and this happened. Where the hell did this happen? Newport Beach. Newport Beach. What a fantastic place to visit. Newport Beach. So yes, so that's one of the success stories that I will get posted as soon as I can, and we'll get to some of the other ones if we have time here in the big show. Which, if you want to join me, it's 218-632-9399. 218-632-9399. I don't think anyone has pinged me for a Skype call, so we got a new caller. We've got, looks like Dallas. Well, I'm not sure. We'll just say it's, we have area code 952. You're live on the No State Project. What's your name? Where are you calling from?
This is T-Raz from the Midwest.
Whoa. Your audio sounds terrible. You just...
There you go. Is that better?
Not much. What was your name?
This is T-Raz.
And you're calling from Texas?
From the Midwest.
Okay, we'll put down Midwest. That's fine. What do you got for us today?
Well, okay, so we've spoken before through Skype, but never really spoken yet together on the phone. And you sent me some of the motions to send into the court. So I filed that. And this was due to a possession charge from driving with no headlights. And so I followed your instructions, and I sent in both of those, the motions. Motion to dismiss and Brady request. And she replied. She was able to send me back. She was able to send me back just the standard discovery. The only thing that was kind of Brady related was the small part on the bottom of the note. Additionally, please note that there is no material regarding any disciplinary actions against Officer Spillers. And so I was wondering if that was what the Brady is for, and how do I address that?
Well, Brady does include that, obviously. If there's been disciplinary actions because he's been dishonest on the job, or he's broken the sacred law while he was on the job, that's obviously Brady material. So she at least is being somewhat responsive to that, which is impressive, because typically they just tell you nothing. We're not required. We're not required. I believe that, and I've read the Brady material has to do with any information that can be used to impeach their witnesses. And so it's why we're asking in there, do you have any, what's the name of any witnesses with personal firsthand knowledge that the Constitution and Code apply, because you're physically in, I'm just going to say Texas. And so they are then required to do as you or I would do whether a defense or you're the accuser, the plaintiff, you're not permitted to call a witness that doesn't have personal knowledge. You have to be qualified. And you have an obligation to not waste everyone's time, to investigate and question them and determine whether they have such personal knowledge. Because if it comes out in court that they obviously weren't qualified, that should fall on you. Whoever. So here it would be the prosecution. Did the prosecution find out if the police officers had such personal knowledge? And since they're responsible to do that, they have to give you the answer to that. Does the witness have such personal knowledge? Since they are going to be testifying that you violated the law. So do they have personal firsthand knowledge that they apply in the first place? Did they put anything like, and now if they don't put anything like that in the response, then they're violating Brady. They're not giving you such disclosure. So I would follow up and say, I need it in explicit terms. I may have updated the discovery request to reflect this, that I need in explicit terms. Does the witness you rely on, do they have personal firsthand knowledge? Yes or no? That's what should be in the response. So every Brady response should have a yes or a no to that issue. And we shouldn't have to make it super explicit, but it may be easier to hold them accountable after the fact when you're in court and they haven't done that. So that's how I would respond. Do they have personal knowledge of this?
Okay. Yeah, the interesting thing is I did give her a call, and then she stated that for the motion to dismiss, she has, as of right now, she has no evidence of jurisdiction. It's either she said that or she just says that as of right now, I don't have any evidence. It's one of the two. I recorded it, but it was just too messed up, the audio.
Oh. So when she said that, how did you respond? Do you remember?
Honestly, I didn't want to ask her too many questions because I didn't really read through the motions, and I wanted to, have more opinions before I actually, follow through. I didn't say nothing. I just said okay. All right.
Now that we're analyzing this for your benefit and for those listening.
Yeah.
What do you think would be an effective follow-up when she says she doesn't have such evidence?
Ask her, well, then what evidence are you relying on to have me brought into court?
Well, she's already saying she doesn't. So I think a better question I would have been, because when you said it, my first instinct is, so let me see if I understand this correctly. You filed a complaint against me knowing you didn't have evidence against me.
Okay, yeah. That sounds...
So what's the significance of that? Why do you think what my motivation would be, why I think it's important to ask a question like that?
Because in order to make a case, you need jurisdiction.
Yes, and also to have a valid cause of action, a valid case against them, you have to have, the injury and the damage. You have to have the act and the result. And here they're going to be claiming that that you violated the code. Well, to violate the code, it has to apply to you in the first place. So it's an element to the charge. You can't prove that you violated the code if you can't prove it applies. You can assume it applies, but that's not proving it applies. So I'm bringing out there's extreme bad faith here. They knowingly filed or recklessly filed this complaint against you. They either knew that there was no evidence to justify filing against you, or they were reckless in not knowing. And it might be because they were reckless in not knowing because it's just not something that they do. Now that you've brought it up and you can gather date and time that you spoke to them, you can now file a motion to dismiss for prosecutorial misconduct, which you could just email me for that. I don't send it with the original. I don't send it when you order the motion to dismiss paperwork because I don't want to overwhelm people. So I just we do the show twice a week. We let if you need the motion to dismiss template for prosecutorial misconduct, just contact me at markstevens@mail.com or markstevens just on the website too, and I can send that to you. The fact that she is continuing to prosecute you is evidence of prosecutorial misconduct. Even if we give her a pass that she didn't know until that moment you brought it up, she is on the hook. As soon as she got off the phone with you, she should have went and did what this prosecutor did in California for Elliott. They should have filed a motion to withdraw their complaint. That's good faith. But here to continue prosecuting you without such evidence, because now in your follow-up, you need to put that in there. You know there's no evidence, so your witness couldn't possibly be qualified because they can't have personal knowledge of something you don't have. Mm-hmm. This is a huge this is a very big issue, and contact me off air after the show, and I will send you a copy of that. And if you have a trial date already, I would get this calendared for a hearing prior to the trial. But you probably have a pretrial conference coming up, so you can hammer away at her then. But I'd still first file the motion to dismiss for prosecutorial misconduct.
Great, yeah.
And
that explains everything as to why she was she was more reserved as the phone call kept going on, she felt scared in a way from her speech and stuff.
Of course. The millennials would say that was savage. You took a professional prosecutor and asked a simple question about evidence her claims are based on, and she admitted to you. She was probably, I can't believe I said that. The regret is probably, an accurate statement of how she was. She couldn't believe, she said she had no evidence. She's a prosecutor. Mm-hmm. So, I can certainly understand why her temperament changed. Now, for me, usually the temperament becomes one of anger, and that they're very pissed off to where they make an admission like that, and then they start talking about, well, I don't have to prove that, and the judge will let me. You just admitted to a felony. It reminds me of how Chuck screwed his brother on Better Call Saul. Do you know okay, so for those who may not know what I'm talking about, prosecutorial misconduct is a felony in that it's an obstruction of justice. And you're filing a false complaint. That's a felony. At both. And when she admits, I don't have the evidence, I don't need the evidence, and the judge will let me, are you admitting to a conspiracy? Really? I mean, that's what it sounds like to me. I'm certain that if I said something like that to a prosecutor, hey, tough guy, come down over here. What are you talking about? Hey, I don't have to do that, and the judge is not going to he is not going to make me do that. I'm like, how the hell do you know the judge will let you get away with arguing without evidence? So that's usually what happens, though. So if you listen, there was a prosecutor in Saskatoon who pulled that crap. She actually said that. And so the follow-up, you should always say, let me see if I understand you correctly. You can argue without evidence, and you know in advance the judge will allow it. Is that what you're saying to me? She backed off, and in most situations, they back off. She probably was very reserved because she wants to be very careful not to make another stupid admission against you, towards you like that you can use against her.
Yeah, probably. And she kept talking about Brady, but she didn't really send me much except for what I was telling you. I was looking online, and I came across an article that says, and I wanted to ask you, can I motion to dismiss due to a failure violation of due process, clauses of Fifth and 14th Amendment?
I would, it's a due process violation. But the motion to dismiss for prosecutorial misconduct is a due process violation motion. They all are violations of due process, basically. They're arguing without evidence. That's prosecutorial misconduct. They violated Brady. That is a due process violation. So you don't have to file a separate motion from the motion to dismiss for prosecutorial misconduct. It's in there.
Mm-hmm. Okay.
Yeah, those are pretty serious violations. If the appellate courts for a number of years have been saying that Brady violations are an epidemic. Prosecutorial misconduct is at epidemic levels. Epidemic. No court. When they say that, you're basically saying no court is safe. If you are in court, you may more than likely be the victim of prosecutorial misconduct. That's what they meant when it was at epidemic levels. They said only judges can, I think it was Kozinski was the judge that said that, who otherwise is a real scumbag. But he was saying that only judges can curtail it. And when you got pieces of filth like Michael Cox of Adams County, Colorado, who are willing to back the prosecution to a point that he'll put a man in a psych ward for asking a question, it's not going away anytime soon. But my point is, to answer your question, these are serious due process violations. And we frame it that they're violating their obligation to comply with due process, not that they violated my due process rights.
Okay. Great.
Okay. So, did you have any other questions?
I think that's about it. But I had other ones, but I can't think of it right now.
Okay. Well, get with me after the show, and I will email you a copy of the motion to dismiss for prosecutorial misconduct. And definitely stay in touch with me and let me know how this goes.
All right. Thank you so much, Bart.
You're welcome.
Speaking to you.
I appreciate the call. And this is what we're up against. They don't like to be challenged. They don't like to even be asked a question. What kind of an adult, what kind of person calls himself a professional and won't answer a simple question? Somebody who's he's got your life in his hands. And this bastard can't he can't even answer a question of somebody he's forced to be there. Well, that's the point. Forcing people to do what you want and forcing people to be in your courtroom means never having to answer a question like an adult. It means never having to take a damn responsibility for your actions. Why? Because you could just throw someone's butt into a prison cell. You could just scare the living crap out of them by threatening a psych evaluation. And that's what Michael Cox is the latest criminal that I'm aware of to do that. But something that interests me, I wrote it down here. I wrote it down. It's very important. Based on what the caller just said. Look, we don't get that many opportunities to question prosecutors, especially when it's outside of court, like what he was doing here, pre-trial. They typically don't like to speak to us for obvious reasons. No evidence in jurisdiction. She didn't have the evidence he was looking for. But they don't need it. Yeah, I know. Fungal, they got a prison system. I get that they're criminals. I get it. That's why we want a society without them. We want them gone. We don't want them to have the platform to hurt people. We don't want them to have the platform and the immunity to be able to put someone in jail for 90 days for asking a question. We're trying to rid them we're trying to get them out of society. We want them gone. We don't want people, we're trying to educate people that that's not right. That's abhorrent behavior. Who cares if he's called a judge? Who gives a damn if he wears that silly black robe and sits 4 feet off the floor? That is wrong. We're dealing with crooks. We don't have that much time. The reason why we go right for the throat. Does the prosecution have sufficient proof? Because we don't have the time to get into the valid cause of action. We don't have the time, the luxury, the privilege to be able to start asking questions like we're in prior scripts. Great questions, but only appropriate when you have the time. Am I entitled to a fair trial? Yes. Can I get one if there's a conflict of interest? No. Who do you work for here, sir? Who are you acting on behalf of? Oh my gosh. You can't ask me fungal. Crooks. We're trying to rid society of these crooks. We want it so that people understand they're just crooks. It is not okay. They do not have a right to treat us this way, natural or otherwise. There is no moral or ethical justification to treat other people that way. And we're breaking down the conditioning. We're breaking down those perceptions. It is not okay to do that. So because we don't have that much time, and listen to the call of shames. I know some of them are edited because of personal information, but they rarely go more than a few minutes. There's a reason for that. These people are narcissists. They have psychopathic tendencies, sociopath, antisocial, whatever you're calling it today. I don't give a damn for our purposes. I don't care why they got that way. We just want to learn on how to deal with them to effectively limit the damage these animals, these predators want to do to us. So because we know we generally don't have that much time, you have to be effective. Well, that doesn't mean that if you're more effective, they'll just drop it. You could do everything right. Look at our friend Bill in New Hampshire. You get all these admissions, and they'll just turn around and say, fungal back. We got a prison system. We don't care. We don't need evidence. We're crooks. We don't need evidence. But you have to prep. I know I have to start another Skype chat, and I'm going to do that. But we also have the forum, and the chats are still fairly pretty damn functional. You have to do the role playing. Go to a city council meeting. You have to engage other people in this so that when you are talking to them, you don't have to report back to me, I didn't feel comfortable asking more questions. That is our job. We ask questions. That is the tactic. That is the method for helping to get these things tossed out. We are defending ourselves with questions. Because most of the time with a gun, it's just not practical. And yes, there are a lot of situations where using a gun is morally justified. If they're going to be attacking you under the guise of some sacred rule from 200 years ago that they don't have any proof it applies to anybody, admittedly, then yes, a gun, in some circumstances, not necessarily deadly force, but a gun to stand your ground is necessary. You have to be able to ask them the questions. And I get it. I've gone through this for 20 years. I understand. Most people just accept as a matter of it's a sacred cow. Of course the laws apply. Of course they do. Maybe I'm a jerk, but I'm going to err on the side of skepticism and logic and reason. I want some proof. If it's true, you can prove it, right? If I'm going to sit here on the show and run my Sicilian mouth, well, I'm Irish too, my Sicilian Irish mouth, I'm a Mick Guinea. If I'm going to make a claim, I'm expected to have proof, right? And I'm just some putz from Long Island who's not interfering in your life. I don't force anybody. But these people are forcing us. They're supposed to have evidence. They're supposed to have proof. Legal logic, we don't need proof. Fungal, we do that every time now. You're a crook. Again, anybody who says they don't need evidence is a crook. Crook. So when you see Honorable Michael Cox Honorable here means crook. Crook. So you should never shy away from the questions, even if you feel uncomfortable. Especially here when she made the admission. And I have enough on markstevens.net. They don't have any evidence. You don't have to be concerned. What do I do if they have proof? If they got the proof, great. Let's report it on the show. They don't. So you're really just dealing with all their excuses for not having the proof. And we discuss many times on the show. Well, what do you do when they say that? I think one of them, Jameson, asked on YouTube. What do you do if you're asking for evidence and they say that you're in the territory? You're physically here, dude. That's not an answer to the question, is it? If I'm asking for the evidence to support their claim that just because I'm physically in Arizona and they just say you're here, all they're doing is repeating the claim, right? How the hell is that an answer to the question? Why is 4 plus 4 8? Because it's 4 plus 4. Yeah, but why is it 8? Because of 4. It's easy to answer the question, but you're not answering the question if you just repeat the claim. And that is exactly what they're doing. Now, they could say that, well, you're in the state. Objection. What the hell are you trying to convey to me? Are you talking about my physical location in Arizona? Okay, fine. You're still just repeating the question, the claim. How many times do we have to say that's called a proof by assertion fallacy? You just keep repeating it. Because you're here, 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 because you're here. Why do you think that your rules apply to me just because I'm here? Because you're here. The laws apply because the laws say so. Mind-numbingly stupid. You don't need to, but if you have the opportunity, if you have the time to get into it, especially if you're not going to really have the opportunity to do it if you're in court. But if they start talking about state, yes, you can, through asking questions. Sir, you're saying that, okay, I think I understand what you're saying. Let's see if I got it right here. Let me draw you an analogy. If you are physically inside the Phoenix Catholic parish, okay, does that mean you're a member of the church? Well, no, but you're physically in those boundaries. Why wouldn't you be a member of the church? Why wouldn't you be in the church? You're in the parish. No, I'm not in the parish. I'm just within these lines drawn by somebody in a black robe. Or purple or white, whatever it happens to be. What the hell is the difference? I'm within these physical lines drawn on the map by somebody in a robe too. What makes you think I'm within the city of Mesa when the city of Mesa is a corporation? Even if we don't use that. Oh, and it very well is. It's a municipal corporation. It didn't exist prior to a certain... Just like the state of Arizona. The state of Arizona is a corporation. It didn't exist prior to February of 1912. Didn't exist. Well, the territory in a legal sense, because it was part of the federal government. It was a subdivision of another corporation. But the ground always, we got billions and billions and billions of years that Arizona, what we call Arizona, has existed. That's there. So we bone up and we practice our Socratic method. Again, why do we use the Socratic method? Because the burden of proof, logic dictates, even in legal logic, the burden is on the accuser. We always want to use the path of least resistance. Oh, you think your claim is true. Can you prove it? Oh, you can. That's a great question to ask, by the way. Can you prove? Before you even ask them for evidence, can you prove that that's true? Oh, yeah. Yeah. Because now you start asking questions. Okay, so your position is if I'm physically in Arizona over here. Your position is... I'm going to drop that. Your position is if I'm physically in Arizona, your Constitution, a written instrument, applies to me. That's right. That's right. Do you have any evidence to prove that that claim is true? I don't have to prove that. Can you? You've already told me you can prove it. So that's the beauty of just asking the questions. It's why I say, treat it like a cross-examination. You know they're going to contradict themselves. They have to contradict themselves. They're crooks. So you ask them in advance. Oh, that's your claim. That's a good claim. It's huge. Can you prove it? Yeah. So then when they say, I don't have to prove that to you, jerky, can you still prove it? You just said a minute ago you can prove it. So, where's your proof? Do you prove a claim just by quoting someone else that says the claim is true? No. No. Oh, what is that? Oh, that's right. It's the old proof by assertion fallacy. Just keep repeating this freaking claim. Just keep going round and round. The laws apply because the laws say so. What does it say on the banner? Yeah, the code is applicable because the code is applicable. And you just go round and round and round. No actual evidence, no rational basis. Just round and around. The code is applicable because the code is applicable. By the way, for those who are new and may not remember, you can go to markstevens.net and you can hear the actual bureaucrat I got that from, because that is a quote. I didn't just make that up for my banner, which you can tell how much effort went into that thing. I think I copied and pasted 4 things. But anyway, that is a quote. That was said to me. And friend Al, who we haven't heard from in a while, was on the line with me. But I have the proof. So you go back in the archives, that's a direct quote. That's what you can expect from crooks. Well, my rules apply because my rules apply, and I'm willing to beat you into submission or use whatever force is necessary to get you to comply. I'll put you in jail and take all the things you own. I'll put your family in the street. I don't care. You will comply with me. I mean, come on, honestly, does that sound like an honorable guy? Oh, if we're talking about Michael Cox, yeah, that's and by honorable you mean lying, stealing, thieving crook. Absolutely. So, in questions, again, this is not it's not sophisticated stuff. It's only groundbreaking in that we are going and focusing the Socratic Method on a sacred cow and using that to break it down. Because that's how you get that's how you get trash like that. That's how you get them to contradict themselves and say things like that. Such as, I'm not prepared to answer that. I have no evidence, sir, but you damn well better have evidence if you're going to try to disprove it. That's how you do it. Yes, they are crooks. I get that. We're defending ourselves against them, and so we should not shy away from asking them these questions. Who, what, where, when, why, and how. These are some of your best friends. And if you write that in at the on the margin of your script, no matter what they say, you can go through that. Take a moment. If you're freaked out, take a moment. There's only 6. It's not like 300. Oh, good gosh, what am I going to do? There's only 6. One of them is going to be appropriate as a follow-up to bring out that what they're saying is not true. Because, hey, they may actually be able to bring out that their claim is true. The Socratic Method can be it's being used to test the veracity of an argument or a claim. It could actually be a valid argument. It could be a valid claim. We're using this as a vehicle to bring out whether it is or not. But we know in advance it couldn't possibly be true. So we rely on those questions and framing it who, what, where, when, why, or how to be able to bring out the contradiction. And so I just went through one simple line to bring out those contradictions. We know they can't prove it. Bill Montgomery's office, you can go to markstevens.net. You can see the county attorney in Maricopa County here in Phoenix. The official position of his office as far as evidence proving the Constitution and Code apply is because they put other people in prison. They did not argue that evidence wasn't required. They never said that. You won't see it. Call them and ask them. They'll talk to Jerry Cobb. I can't get in to speak to Bill Montgomery myself. They won't allow me to. But you can call yourself. You can call the local bureaucrats in your area, and you can ask them the same damn questions. The claim that they don't need evidence is usually made on YouTube. It's usually made on comments. It's usually made by people who are not in government direct, or maybe they're just on the payroll, but they're not prosecutors that typically say that. More of those claims are made outside of court. Prosecutorial misconduct. And again, you were asking questions. If they're going to say, I don't have to prove that, so I can argue against you, and I can accuse you of being a criminal, and I don't need any proof. Yeah, double standards suck. We're on the end of that damn double standard. Not the one in court. Not the prosecutors trying to get away with it. We're on the end of that damn double standard. And is a double standard fair? No, because they give lip service. All are supposed to be equal under the law. Really? Why are prosecutors allowed to argue without evidence and we can't? Why can they argue without evidence, but if we're going to prove it wrong, we need evidence? We can't just point out that they have no evidence. No, that's not enough for us. We have to have proof. Why would you need proof to disprove something that is completely unsupported by logic, reason, and evidence? The best that they can do is to say, I know a guy who knows a guy who knows another guy. That's called precedent. Well, I read it in a book. That reminds me, there was a great line from Beavis and Butthead, which was just a brutal critique on American society. And they're in classroom and someone's talking about dinosaurs or something, I forget. And Beavis says, is that true? And I think Butthead slaps him in the face. Of course it's true. It's in a book. So when you turn around and say that your claim is right because somebody said it and it's in a book, you're being just as stupid and irrational as what Mike Judge was bringing out in Beavis and Butthead. Well, of course it's true. It's in a book. We have these books and it says it in there. Ay. These people are held up as authorities and that they're smart and they're this and they're right. No, just because they've said it doesn't mean it's true. Just because some psychopath like Michael Cox in Adams County, Colorado, says that somebody is insane for asking a question doesn't mean for a moment that Michael Cox is accurate. It's ridiculous. So we have to prep for when we're going to engage these people so that we can bring out these contradictions. Is it weird to ask for evidence that the laws apply? Yeah. Is it necessary? Is it relevant to ask? Of course it is, because their entire claim is based on it. Nothing is relevant without that. And if we're going to effectively defend ourselves, even if we're going to make a deal like Nick was able to do in Adelaide, Australia, no time, no fine, but a year's worth of probation, and he was looking at 100 years. But you got to prep, and you got to hold their feet to the fire, and at least get some leverage on them. Our caller is in a great position to possibly make a deal because they have their admission Look, you've already admitted that you have no evidence. We can either go forward and argue prosecutorial misconduct, which I will argue on appeal, by the way, or you can drop this completely or just give me a token fine, which I'm happy to pay for right now. That's some leverage because you go in and you effectively ask questions and hold their feet to the fire. You ask them questions to support their claims, and they can't do that. Because bottom line, even if you're a critic of the show, if you have any honesty whatsoever, you have to admit they can't possibly prove that these laws apply to anybody and create obligations on them. You have to admit at least that much. I mean, even that one critic I had on admitted it's arbitrary, admitted that they don't, there's no evidence they apply. There couldn't be. Yeah, of course. Well, been fun on this broadcast. I want to give the information one more time regarding Jackalope. Going to be at Bacchus Meadow in Arizona, about an hour and a half or so north of Phoenix. Beautiful, beautiful area. Absolutely gorgeous. It's huge. It's July 31st to August 6th. And you can go to, I'll put the link, but it's jackfest.rainberry.com, and rain is spelled with Y, Rayne, berry. I'll probably put that down there so it's easier to see. It is a good time. It's a lot of fun. It's anarchist. It's not a minarchy get-together. Pretty much everyone there is a no state, no government anarchist, do no harm kind of people. A lot of fun. And I know it's rained before, but last year was absolutely astounding. It was beautiful, maybe a little windy, but I'm not going to have that stupid banner this time. Good time. It's a good time. So, again, this has been episode 20 of the No State Project Wednesday edition. It's May 10th, 2017. And I will not be live this coming Saturday, but I probably have some pre-records for you. So, until then, salud.